Good evening. Welcome to the Fifth Ward regularly scheduled community meeting. This is Councilwoman Cosby here in the Fifth Ward. We won't delay the start of the meeting. If you have ever attended the meeting, you know I like to start on time. So with that being said, I want to just let you know that tonight's guest is we have a presentation, but it's going to be a conversation. And the conversation is about estate planning. Do you have a will? Why you need a will? And how to go through the process, of probate if, when someone passes away. So we have invited the Essex County Surrogate's office, and they graciously agreed to come. And we also have here our surrogate from Union County who has joined. So without any further delay, so I'm going to introduce you, and then after the presentation, I'll give an update on Fifth Ward specific items. So we're going to be joined first by the community liaison, Ms. Nikki Hamilton Moore. Welcome and thank you for joining us. So the Essex County Surrogate's office, tell us in short what they can do as far as community outreach and how they can contact you if they have any questions or would like to have.
Certainly. Thank you so much, Councilwoman Cosby, for allowing the Essex County Surrogate Court to educate on wills, trust, and estate planning. At this time, we do have on deck 2 to 3 representatives from our particular court, as well as an additional representative outside, because we cannot provide procedural questions, so to speak, because I am a court representative. We are located in a brand new building today at 495 Dr. Martin Luther King Jr. Boulevard, second floor in Newark, New Jersey. You'll be able to communicate with our Alterique Kenny, which is our Essex County surrogate, as well as our deputy surrogate, DeVero McDougall. And on deck behind him would be Michelle Ferrer, which is an outside attorney that was able to come on and help educate and answer questions as a court that we cannot provide to you. So we thank you so much for the platform, as well as your surrogate in the Union County area.
Yes. So I'm going to bring in your surrogate first, because I know that he's busy. Just let him introduce himself. And good evening, Surrogate Kenny. How are you? Good to see you.
Good evening, Councilwoman. How's everything?
Everything is good. I appreciate you. I know you're a dad and your weekend's coming up, so I know you're out and about doing a lot of things. So thank you very much for being here.
Thank you very much. And I appreciate you inviting us, as well as allowing us to collaborate with your county surrogate as well. I just want to say some brief remarks before I go, because I do have young people in the background who are going to make some noise, and I just don't want to interrupt this conversation. So we decided to create an office for community outreach for these very purposes, to talk to talk to communities, primarily of color. That was, one of our intentions. But of course, we service all municipalities in our county. And we wanted to talk with them about estate planning, why it was critically important, why some people felt that, their circumstances didn't meet the needs of surrogate court, until they found out, everyone is impacted by surrogate court at some point. And so whether it was guardianship, whether it was administration, and today we're having a conversation about estate planning, we wanted to make sure that we talk to people wherever they are and have them ask important questions about these sort of related issues regarding estate planning. So thank you, Councilwoman, for having the foresight to make sure that your constituents are informed, are prepared, as well as are aware of the services that they need to be made aware of. And as Nikki stated earlier, we will only answer procedural questions, but we definitely have a giant in the room, Surrogate LaCourt, who was able to provide a wealth of information. We also was able to partner with some attorneys who volunteered their time and services, as in Michelle, and we also have DeVero McDougall, who's one of the smartest deputies, throughout the state of New Jersey, who has a dual role of not only managing in our office, but also making sure that the day-to-day affairs in our office are done properly, as an attorney as well as a CPA. So we actually stole him, and we're able to keep him, but also able to provide us services as well. So again, thank you, Councilwoman. Thank you, Nikki,
Sure.
for continuing to provide, communities, information, as well as allowing us to talk directly with people. And also let us know exactly how we can do our job better. Because as we listen to people, we also try to learn of what we do, how we can inform people at a better, to do it better, but also to also make sure that we inform people as well as what we do and what our limitations are. So thank you, everyone. I have to get back to dad duty, so thank you very much.
Thank you for coming, and happy Father's Day to you.
And happy Juneteenth as well. Thank you very much.
Celebrate freedom.
Freedom.
Take care.
Thank you, sir.
You.
Bye-bye.
Yeah. Just full disclosure, my technician is off tonight. She is not here, so I'll be looking down. So I do apologize. I'm not ignoring anyone. I'm going to bring in the deputy surrogate, and I'm also going to bring in the attorney who was referenced, Ms. Michelle, who is a volunteer. So thank you all again. Thank you everyone for being here. We're not going to share and do a slideshow. We're just going to give, generic information, if you will. I know that Mr. Kinney did mention in something that I didn't even know, that your office actually handles or helps with garnishment?
Not garnishment. He was speaking of guardianship, adult guardianship.
Guardianship. Okay, right. I knew that.
Yes.
Okay.
Adult guardianship.
So just give us a rundown of the services and when someone would need them.
And real quick, is Surrogate LaCourt still here?
He is not back. Let me just try and scroll down. Let me see. No, he's not back. And I have to remove. Yeah. So you're certain. Then there's Jim. This is a free program. Did I say that?
Yes.
So you're limited to how many people you can have on here. So let me just find you. I'm gonna kick myself out. As a matter of fact, I don't need to see me. Mr. LaCourt, can you hear us? Because we see you. We see the darkness. I just want to let you know that you're here as we begin to go through. All right, he's going to come in.
Okay.
It's buffering. I see that. You see it.
There he is.
Mm-hmm.
So Surrogate LaCourt is here, and everyone has just met Surrogate Kinney from Essex. It was important for us to make sure that as our attorney here, Michelle Ferreira, is on, that we not only reach out our communities but other communities, and we've done this before with Surrogate LaCourt, and so we try, all the Surrogates Court try to work with each other, because what we understand is all our constituents need this information. It's not about politics. It's about getting the information out there. And so we started this. Essex County started this last summer at the height of the pandemic. And as I said, Surrogate LaCourt and other surrogates have come on to work with us to get this information out to individuals, because we no longer, at that time, we could no longer go out and actually physically see people. So we went where they were, and Zoom and StreamYard and YouTube, that's where they were. And so that's where we went. So we, like the Surrogate Kinney said, we definitely appreciate being here. And just real quickly, just to let people know that each county has a surrogate, and a surrogate is a constitutional officer, which simply means that the New Jersey State Constitution has created the office of the surrogate. The surrogate court is a court of limited jurisdiction, and that simply means that there are things that we can do and we can't do in that capacity. So we have the surrogates have a dual role. The surrogate is the judge of probate court and the deputy clerk of Superior Court Chancery Division probate part. So what we can't do in probate court, we have to then transfer that over to a probate part judge for that judge to make a decision. But generally speaking, our responsibility is to probate wills. When an individual has a will, that means they died testate. When they don't have a will, they die intestate. And then we have to go by the New Jersey State statute, intestate statute, in determining who the administrator will be. With the will, you're an executor. Duties are the same, just different titles. When we cannot act, and for instance, we will turn that over to Superior Court. And so also part of our role, as he's talked about adult guardianship, if somebody does not properly plan with the proper documents, which Michelle will talk about, and sometimes they could plan properly, but certain things like gift giving, if it's not done correctly and it's not done before the person becomes incapacitated, they're going to be required to do adult guardianship, which a judge is going to have to do two things. One, declare the person incapacitated, and then two, appoint somebody to be the administrator. But hopefully tonight with this compensation, we won't have to, and everybody listening won't have to worry about administration because they're going to have a will. And they're not going to have to pretty much worry about adult guardianship because they're going to have the other necessary documents that they're going to need. And so that's our basic responsibility. We do a couple of other things, but that's our basic responsibilities. And the premise of this conversation you want us to have today, because as Surrogate Law Court can attest to, when many people come to the Surrogate Court, it's one of the toughest times in their life because they just lost a loved one. And so there's added stress on top of that when that loved one did not properly plan and do a will. And people get frustrated. And, and so besides, like I said, besides being, depressed and saddened for the loss of a loved one, now they're angry and they're frustrated because they realize that this process is a chore. And so part of our outreach. Yes.
Do you mind if can I add something?
Sure, go ahead, Ed.
I'm sorry, I didn't mean to interrupt. Were you finished with?
I was gonna introduce you when he finished.
All right, I'm sorry. Go ahead. Go ahead, DeBarrow. Go ahead.
So part of our outreach is just to ensure that people plan to do their estate planning ahead of time before they come to us, so it can make the process as easy as possible. As Surrogate Court will tell you, and as Surrogate Kenny has indicated earlier, our goal is just to get information out there. That's why Michelle is on, and we appreciate being here. And I will participate, answer any procedural questions along with Surrogate Court. And with that, I'm going to turn it over to Surrogate Court so he can go ahead and add some words as well.
So let me introduce our surrogate. He is James LaCourt. And thank you for coming, because this was my second time, reaching out and trying to get this done through the pandemic. And I totally understand that it's a thing for your office. You guys are super busy. So thank you for joining us.
I'm sorry about the last time, but we were really slammed with the COVID-related fatalities last year.
Right.
And yeah, Union County, especially Elizabeth, was hit extremely hard by the COVID. A lot of our nursing homes were not properly guided through the process, and they suffered a tremendous loss of life in local nursing homes. However, I'm here today, and I'm going to try to supplement what DeVero just said. Let me just clarify one thing. Although the duties are the same between an executor and an executor being in charge when there's a will and appointed by the decedent, and an administrator being in charge appointed by me. So right away, at least in Union County, you can see the difference, that the testator can appoint whoever he wants to be in charge of his estate, whereas I will make a decision and it might not agree with what the testator was going to do. Additionally, it's quite possible that a surety bond, may have to be imposed on an administration, which would be an added cost to the estate. In other words, every year, the premium is going to have to be paid on a surety bond and an administration. Now, in most wills, it specifically will state that no bond is required, and therefore it'll save additional funds being expended if there's a last will and testament. And to bring it down to, or to bring it around to everybody's form of thinking, and I think I could best summarize it this way, and maybe it'll be easier for you to remember, for people to remember. People go to church every Sunday. That's a great thing, because they want to wind up in the right place when the time comes. But those same people that may go to church every Sunday don't have the last will and testament. And while they may avoid going to what I'm going to just say out front is hell, they're going to leave hell back here on earth when they do go. And the point is that I don't think anybody wants to do that. And if people think that the kids will be able to sort it out when the time comes. I have personal experience that's going to be able to tell you that a lot of kids can't work it out. And as a result, it could lead to costly, expensive litigation, which may result in certainly hard feelings amongst the children, and it may result in an expenditure of funds that will severely deplete the estate. And thirdly, people could wind up with a distribution that the testator never wanted them to have. So that's why it's important for everyone to have a last will and testament. If I could just
agree. So, but when you say that, so I want to bring Michelle in and ask her legally. So we've had issues in our family, and there's no will and whatever like that. Silly question. Are the wills that you would download from like LegalZoom, are those okay, provided that they are, complete and notarized, or are there special like wills that have to be prepared?
Well, first, I just want to say thank you for having me.
My pleasure.
Well, I can't really say that I've ever reviewed a will done from LegalZoom that I've actually liked.
Really?
So I don't encourage anyone to use LegalZoom. A will doesn't have to be that costly or that complicated, but every state has different rules on what's a properly executed will, what needs to be in the will. It doesn't vary that much, but at the end of the day, you really should have an attorney review it. It should probably cost the same to prepare it than it is to actually review something that's downloaded and then from the internet and then add wording in. I would never encourage anybody to do something on LegalZoom. Let's just say that. I don't want to, I don't want to say anything ill about LegalZoom. I don't think it can't replace, having an attorney actually draft the document and ensure that it's properly executed and that it accomplishes your wishes. Because you may have overlooked something or a question that you don't even know to ask. At a very basic level, there are 3 documents. I don't know if you want me to go into them now as to, for a very basic estate plan, what you want me to start discussing that a little bit?
So if you could just like highlight what the 3 basic forms are.
Yep.
And if anybody's interested in receiving a full presentation, they can email me and I can send out the presentation, that was prepared. And we're not going to go through all of it, but just if you can give us the 3 basics, that would be awesome.
Sure. So at a very basic level, a basic estate plan is going to have a last will and testament, a financial power of attorney, and a healthcare power of attorney. Now, the will is going to dictate what happens to your assets upon your death. Now, a will is very important because it lets you name who your executor is, as was discussed before. It may actually, you can waive the bond. You can decide who's going to inherit what and when. So if you have minor children, it's really important as well because you'll be able to name guardians for your minor children. You'll also be able to plan for individuals with special needs. So having a will is really important. In the will, you can actually have testamentary trusts created. And those trusts will allow you to plan for minor children, for a spouse, let's say, if you're going to leave everything to a spouse and that spouse is then going to remarry upon your, not immediately upon your death, but maybe if, it's a younger couple after, the first spouse dies, maybe you want to leave things in trust for the survivor to ensure that a subsequent marriage won't affect where your funds are going to ultimately end up. Okay. Because it could end up, let's say, there's a couple, they leave something to, their outright wills to each other. It's a young couple, the husband passes away, the wife inherits everything, wife remarries, forgets to update their will. They had children, and now it's going, or the assets are going primarily to that, that spouse, surviving spouse's future husband instead of the children. So things like that, just things that LegalZoom, again, going back to your initial question, wouldn't know to ask, and you wouldn't know that you missed it. But so the will obviously plans for what happens after you die. Now, during your lifetime, if you want to plan for incapacity and potentially avoid the need for an adult guardianship, you'll need a financial durable power of attorney and possibly a healthcare power of attorney. Now, both documents are really important. They're going to give somebody the authority to act on your behalf if you cannot do it yourself. The healthcare one in particular is really important, and I find that not a lot of people think it's necessary, but it really is. You can have a combined document that states what your medical wishes are, what your end of life care decisions are, and then it's going to appoint a person to make those decisions for you if you cannot make them yourself. Now, if you don't have these two documents and you become incapacitated, your loved ones will probably have to run to court to get a guardianship over you. So it is important to have these two documents to plan for incapacity during your lifetime. I can't stress enough how important it is. I think it's just as important or more important than your will, to be honest with you, to ensure that you have these documents in place.
Okay.
And again, with the will, you can do a lot. You can plan for individuals with special needs. You can plan again for subsequent for minors. Subsequent marriages, divorces of children. You leave things to adult children, and you can actually leave things in trust for them as opposed to outright, so that you can potentially protect it from being subject to equitable distribution in a divorce. So there's lots of things you can do in planning to ensure that, and ensure that like a 21-year-old doesn't inherit a large sum of money as well and sort of blow it unnecessarily. So some of the major reasons, most important reasons to have these documents in place. Also, the peace of mind. Once you get it done, I find that most people think about me when they're about to board a plane. And so, or somebody will call me, I'm going on vacation in 2 days. Can you draft a will for me? I'm like, well, I don't think we have time to do that right now, but why don't you call me when you come back from vacation? But once you have it in place, I think it gives everybody peace of mind. And you're also really, really helping your loved ones, because if not, you really are, like the surrogate said, you really are leaving them with a mess.
Right.
You're already going to be going, you're going to be mourning your loss. So that it can be, less burdensome for them.
So the durable power of attorney is for finance and for medical, or that could be one document, right?
You want to do two separate ones, one for the financial decisions. A general durable power of attorney is more for the financial decisions. And then there's a healthcare power of attorney that can be called an advanced medical directive. Sometimes people call it a living will, a proxy. You can make that one document where it's the proxy, naming the person who's going to make the decisions for you, and also actually having the living will component, the directive, which is going to say what you want in the event that you cannot make decisions for yourself. Like, do you want to be resuscitated? Do you want your life artificially prolonged by a machine? Those kind of questions. Do you want to donate your organs? That's all in the healthcare power of attorney. I like to call it healthcare power of attorney simply because it differentiates from the financial one. But people call it all sorts of things. Advanced medical directive, as I said. Sometimes people call it a living will, healthcare proxy, all that.
Yeah, so I watch a lot of Grey's Anatomy, and I be hearing them. They're like, "Oh, she has a DNR and all kind of stuff," and I'd be like, "Oh, well, my goodness!" But no, I'm just joking. But I mean, people in real life scenarios, like, may she rest in peace. My mother had a DNR, and she survived a heart attack, and it ultimately took her out many years later. But I was sitting there like, "Damn, she has a DNR." Like, like, what are we going to do right now? Because I knew, and so yeah.
But it's a very personal decision. You don't want to leave that burden to your loved ones, because then, first of all, they don't know what you want, and it's hard for them as it is, and you don't want them to have to make a decision for you without knowing what your wishes are. So put it on paper, appoint somebody to make the decisions for you if you can't do it, and you're not only helping yourself, but you're helping them, because it's a burden on the person you approach.
True. So let me ask the Union County Circuit, Mr. LaCour, can you tell the folks? I put up what I found for the phone number the email, but you're not in a new fancy building like Essex County, but tell the folks how they can locate you and your office.
Well, once they let the public back in, we're in the Union County Courthouse in Elizabeth. The public has been excluded from the building ever since the pandemic started. However, we can be reached by email, jlacourt, that's LACORTE, at ucnj.org. We can be reached by fax, which is 908-351-9212. Let me repeat that, 908-351-9212. And that takes care of email, fax, and we can be reached by what they refer to now as snail mail, I guess, by regular mail. and we'll be able to respond to that. Now, let me just add a real life example, if I can, Roshana, which may
Please.
bring the point home as far as the last will and testament is concerned. Let's use a real life example of what I have seen. We have a couple that's been long separated. The husband moved out 25 years ago, and for various reasons, whether they be religious, whether they be social, whether they be for some other reason, just for the kids' sake, whatever it might be, they haven't had any contact with each other. Okay? And you see that quite a bit. And what'll happen is the kids have come forward. They've taken care of mom. They take her to her doctor's appointments. She's with she's the babysitter in chief. Whenever they need a babysitter, it's always mom, since dad's in Cleveland, Ohio, or someplace like that. Point being that if that lady were to die without a last will and testament, that husband, who hasn't been on the scene for the last 20 years, would inherit everything to the exclusion of the children. Now, that's a stark example, I know, but it's a real example because I've seen it, and it happens at least every single month of the year. Similarly, if a woman has multiple children and she doesn't see her son, okay, he's moved away, he's down in Texas, God knows what he's doing down there, but the daughter takes care of the mother, takes her to bingo, they still have bingo, I assume they do, takes her to Atlantic City, takes her to her doctor's appointments. If she were to die without a last will and testament, those two children would share equally. And I think most people would say, hey, that's not fair. Well, you know what? If that woman had had a last will and testament, then that son could be eliminated from distribution and the daughter would inherit everything. Now, an even more stark example, if I can, let's say that there was only one child who's since dropped out of the picture, but a niece has come forward and treats you the same way as if you were her mother. You're her aunt, but it doesn't matter. She treats you like you're her mother. Now, if you were to die, that niece wouldn't get a thing if you died without a last will and testament, and that son, who you haven't seen for 30 years, would inherit your entire estate. And people say, gee, that's kind of rash. Well, you know what? It happens. It happens every single day. And I think most people would be very dissatisfied if they knew that's how their estate was going to be distributed.
So
Okay?
I have a question here. At what age should you have or prepare a will?
18.
18 years old?
18.
Okay.
You're an adult. Chances are you're going to have something that you want to distribute. Maybe you have a parent that's been more of a parent than the other one has, and you want your parent to wind up with everything.
So when you say everything, are we including life insurance policies in the
life insurance policies are a contract between you and the life insurance company. That means that you've made a contract with the life insurance company to pay a certain individual upon your death. That passes outside of the estate. That's a contract. However, if the beneficiary is not named, or if the beneficiary predeceases the decedent, in other words, dies first, then the proceeds will be made payable to the estate, and therefore it becomes an estate asset. And without a last will and testament, will be distributed according to the scenarios that we've just described.
Got it. Okay. Is there anything else you want to add, Deborah?
So what? Surrogate LaCourt is right on point. Exactly what he mentioned. We see that every day. We have those conversations, and as I said, this is the reason why we want to do this community outreach, so we can explain those things to individuals, so they won't be surprised when they come to Surrogate's Court. Because at the end of the day, there's nothing the Surrogate's Court can do in those situations, because the law has dictated who is entitled to be the administrator, who's entitled to inherit. You're the only one that can change that, as Surrogate LaCourt indicated. And I just want to add on to what Michelle Farah said, or add to what she said in terms of the documents, the important documents, the dual power of attorney, the medical, I'll use her terms, the medical power of attorney. Those are very important. And if nothing has illustrated that more, it's the pandemic that we are now trying to get out of. As Surrogate Court indicated, Elizabeth was hit hard. Essex County was one of the hardest hit areas in New Jersey, along with Hudson. Many people, many people who a couple of people I went to school with died with it. Friends, family. I mean, if you grew up in Essex, went to school in Essex, especially in Newark, which I was raised in Newark, you know somebody who was touched by the pandemic. And many of them were surprised to find out when their loved ones were in the hospital and they didn't have the medical power of attorney that James Surrogate Court's example, it was a niece that took care of the aunt. Well, that niece, doesn't have power to do anything for her, even though she was doing it all along. If nothing was put on paper, she doesn't have that power. So the pandemic has illustrated the importance of these documents that we're talking about today and planning tonight. And so, although Surrogate Court, myself, Surrogate Kenny and Michelle were out there before the pandemic, this has definitely illustrated the importance of these documents. And we hope after tonight and with you continuing to let your constituents know the importance of this, that people are going to get out there and get these basic important documents. And I just want to add one thing, and I'm biased like Michelle, and I'm sure Surrogate Court is biased. LegalZoom and all those, we're not going to bash them, but at the end of the day, they're general. They don't know your situation. They don't know your situation. Just look at it as your doctor. You don't want to go to what's the website, MedX or whatever. You don't want to go to MedX or whatever. You want to go to
WebMD.
See, that's why I don't know it, because I don't go to it. I go to my doctor.
I'm cheap. That's how I know.
I mean, they're good for general stuff, and maybe if you go to a doctor to explain things. But to make a diagnosis, you need to be open and communicate with your doctor to let them know everything. Same with your attorneys. Let's be honest. Some of us have family members who are addicted to drugs or who are terrible at money, and you're embarrassed to tell people. But you have to let your attorney know this, just as you have to let your doctors know what ailments are bothering you, so they can prescribe the right medicine. Same with your attorney. You have to be open so the attorney can properly diagnose the situation and put the right things in there, unlike LegalZoom, which can't do that. So I'm biased, just like Michelle and Surrogate Court, that you want to be open and communicate to not only your attorneys, but to your family members, because you know your family, and you know your family member that who barely can rub two nickels together. You don't want to make them the person in charge of your property, give them, your attorney, in fact, your durable power of attorney.
Yes, I agree. That's awesome advice. I mean, it makes sense. But some of us, like, well, I got a paper and I have it notarized, so that's it. So it makes sense that you have to drill down and make sure that every situation or scenario is mentioned there. So that's okay. I agree.
If I can just add one thing.
Go ahead.
May I? Okay. I just wanted to add also, and I think I briefly touched upon it, also individuals with special needs, just very quickly. If there is an individual that is going to receive a beneficiary in your will, or who would inherit intestate, meaning if you pass away without a will, and that person has special needs and is receiving needs-based governmental assistance, and they inherit from you, they are going to probably lose their needs-based governmental assistance.
Right.
So just keep that in mind. You might think you're helping them by leaving something to them outright, when in the end you're going to make them ineligible. They're going to have to spend that and then thereafter reapply for their benefits. So I know I mentioned it before, but I just wanted to, because we talked about different family situations, I did want to bring that up again. And there are some good forums online. I think the state has a good power of attorney for healthcare, like a medical one that can be used. And it's more of a directive where you would initial what the things you want, and then you can appoint someone there, and as long as you have it witnessed and notarized, it should be fine. If you don't want to hire an attorney, but you should still hire an attorney or have an attorney review what you already have in regards to the general durable power of attorney and also the will. So I'll leave you with that, unless you have other questions for me.
Just one question. So once you have your will, the will stays with you, or what gets filed in the office in advance, if anything?
Well, you can file them if you want, but typically they used to be done very often in the past. Typically, my clients keep it, in a safe place. If it's going to be in a safe deposit box, oftentimes I tell the clients to have somebody on the box with them, named as somebody who can access it. I don't hold the originals anymore. I used to hold them. I give them to the client and I keep digital versions. I find that worst case scenario, and please correct me if I'm wrong, but the courts will accept a digital version if the original signed, raised seal copy is not found.
Okay.
Let me clarify that. The original will cannot be probated. The original will must be probated in the surrogate's court. If it is a copy, we cannot probate that. You are going to have to go to Superior Court probate part, which is going to end up resulting in more money and possibly having to get an attorney to assist you. So you want to keep that original will. There's no such thing as two original wills. There's only one original will. Everything else is a copy. So as Michelle indicated, and let me make another clarification. The will is not filed with the surrogate's court until after the decedent dies. The will is held somewhere, like she was saying. You could put it in a safe deposit box, but I'm not sure if surrogate court has seen this, but in Essex, we've noticed that a lot of the financial institutions are giving people a hard time to get into the safe deposit box. So we have to issue orders to help them get in there. So you might want to have a fireproof box or something to that nature.
Yeah, what's happened is New Jersey banks are not owned by New Jersey corporations anymore.
Right.
A lot of them are from out of state. We're talking Wells Fargo. We're talking Santander, TD Bank. They're all from out of state. So they had their own rules on safety deposit boxes. It used to be you could take out a last will and testament, funeral or burial arrangements, and insurance policies with a named beneficiary. That's not the case anymore. So in all honesty, I might as well do a commercial. If you're going to put your will in a safety deposit box, use a local bank, Union County Savings. Use a bank that's familiar with the laws of the state of New Jersey. Now, I'm not singling out Union County Savings, but I know for a fact that they'll let somebody remove a will when the time comes and the will has to be probated. What DeVero pointed out is very important. A lot of people think that once they do their will, we put it in some humongous file down at the courthouse and take it out when you pass away. That's not the way it works. We only have wills of people that have died at the Union County Courthouse. They're the wills that are probated. We don't have wills for live people. We only have wills for people that have passed on. Okay, so don't think there's a big file in my office that we pull your will out, pull the will out when the time comes. Okay, thank you.
And if you don't mind to add two things to what surrogate court is mentioned. One, let me just point out to everybody, as I mentioned earlier, each county has a surrogate. I just want to point out the surrogate has jurisdiction over wills and administration of an individual that passed away in that county. So
that's correct.
And I'm sorry, not passed away, that lived in that county when they passed away. So
if
you live in Union County you were a resident in Union County when you passed away, your family would go to the surrogate's court in Union County. If you were a resident of Newark, they would go to the Essex County Surrogate's Court. So I wanted to make sure I pointed that out. That surrogate has jurisdiction over that situation.
Okay. Go ahead.
No, you go ahead.
No, here's a question. If the bank knows who you are, right, and your parents would pass away, what happens? Can they actually handle the business because they know you, or is there something specific that needs to be done? So, like, if my mother was doing her banking, I was actually her person who would go and make transactions, but it was not a joint account.
There's no general rule anymore, Lashana. The rule is what the bank says it is. So what we're doing is just issuing orders, even though they're not really provided for in the rules, because we don't want to put the people through hardship and end up in Superior Court to get a will out of a safety deposit box. If the bank, the rules are what the bank says they are. That's just what it comes out to be. So you can check with the bank prior to putting the will in a safety deposit box in that institution, but there's no guarantee that says that the will be easily removed at the time of death. And so the banks make up their own rules.
And so that is true if the will is in safety deposit box. But in terms of in terms of whether you can handle the estate of your mother or your father, in that case, the answer is no. You have to become, if there is no will, you have to become the administrator to handle their estate. If there is a will, you'll be the executor, and then you're responsible for carrying out the business of your parents. So as Surrogate Court said, it's a totally different issue about getting the bank to give you a will if you have it in safe deposit box versus if you try to go into the bank and say, well, you know me, you know my mom had a bank account here years. I want to take the money out. The answer is no. They're not going to let you take it out because they're going to the Surrogates Court and got appointed to be the administrator executor and come back with a short certificate. So you're going to have to come to the Surrogates Court in that county to get appointed to be the fiduciary, to use another word, a fancy word that simply means you're responsible, you're the agent for your parents' estate, because fiduciary can be a fiduciary for guardianship. It's just a fancy word to say ultimately you're the proper person authorized under the law to handle that particular estate.
So I'm not supposed to go use that ATM card. Y'all hear that, right?
Correct.
Just because you know the code. Don't go out there and play on the ATM because they got cameras. But I have a question also. So I'm not trying to be funny. I'm just saying this is what I know happens.
No, you're right.
So
absolutely right.
And where would one put if, for example, they wanted to, if is it in their will, or does the administrator decide about as far as giving money to businesses and organizations, like, you know, upon someone's passing, like if somebody wants to donate to the Civic Association because they've done good work in the community, where would that live?
Don't forget church, or the synagogue. Don't forget that.
Well, see, I wasn't trying to go to the religion. I was just listening. Rashana Cosby Civic Association, be a 501c3.
In the will. It should be in the will.
It should be in the will. Okay.
Yes.
Definitely the will.
All right. So we got to get some will classes, not will classes, but not. So before I say that, y'all got to contact Michelle. I'm just saying, because if you want to get it done right, have the conversation with your family members first. You know, how even small things such as how you want to be, you know, if you want to be laid to rest, right? Or you want to be cremated. So you can tell your kids all day, and then somebody's going to jump up and down and get a horse-driven carriage, and there goes $10,000 from the estate right there that could have went to the grandkids or something. So make sure you guys look at Michelle's information and jot it down, and give her office a call and have those little planning sessions and get those wills done. It's real. COVID has opened up our eyes that it's really a thing, right?
Yes.
Definitely.
Yes.
And I know culturally sometimes it's difficult, or people have superstitions about it. I know in my family, it's like, we don't talk about this because if we talk about it, we're going to die. No, I mean, like, it's something that's necessary. It needs to be done. You're going to feel better once it's done, and you're going to alleviate stresses for yourself and for your loved ones. So I think the whole process can be relatively easy, straightforward, and it will, like I said, alleviate. I think the whole process is to alleviate stress for you and for your loved ones. So I think it's all around a positive experience.
Councilwoman, if I may, I know that Surrogate Court talked about insurance policy. I want to dispel a myth that many people have, because I know it was one of the things with my mother would be like, you're my oldest, I'm going to put you as a beneficiary on an insurance policy. And her presumption is, because she trusted me and thought I was responsible, that I was going to, one, make sure she was buried, and two, share the wealth with my siblings. The reality is, once you name a beneficiary in your insurance policy, they don't have to do anything at all. They don't have a legal obligation to bury you, and nor do they have any legal obligation to share that money with anyone. I know Michelle talked about do you want to leave a 21-year-old money? Same with the insurance policy. You by chance pass away when your child is 18 years old. I mean, I think I was responsible then, but I think I would have gotten a nice big shiny car when I was 18. I actually had a family member who, my aunt died, unfortunately, when I was 17 and he was 18, and I think he went through that money in like 6 months. So trust is very important, but like Michelle was talking about, but more importantly, keep in mind that if your purpose is for insurance money to bury you, you need to either pay for pre-burial or find mechanism of mentioning it in your insurance policy. But don't think that individual is going to bury you because you put their name as a beneficiary on insurance policy.
Can I say something to that real quick? I'm not trying to be funny, but that was a legit episode of Judge Mathis. Like the daughter, the sister was suing the sister because the mother, and it was a thing. And I was like, are they serious? I couldn't believe it. But this is what happens in the real world. Like, so people, this is a real thing. And here's the question. I don't know who wants to take this question. What responsibilities do I have if I'm appointed as an executor of a will? And, you know, what happens? What is their responsibility? Who wants to answer that?
Well, if it's in the will, the responsibility is going to be spelled out. In other words, initially, all the legitimate debts of the estate have to be paid. And administrative fees, burial fees, and legal fees, if any, are preferred. After that, after all the expenses have been paid, then the distribution has been made. However, now, one of the things that people are concerned about is, well, I was left money by my dad in the will, but he had a credit card debt. Do I have to pay that? That's what people are concerned about. And quite simply, it's a debt of the estate. Before the distribution is made to you, the debts have to be satisfied. So if dad died with a credit card debt, even though he left you money, it's going to come off and it's a legitimate debt. In other words, he legitimately charged his charge account. Then that debt will be paid from the estate, and you will receive the net amount after the bills have been paid.
Yeah, but what if the person doesn't want to be the executor? What if they say, "Yeah, no, I'm not doing that"?
You don't have to.
Well, then, usually an alternate is named in a will. If the alternate is not named, then and a debt remains unpaid, a creditor can come forward and be named as the administrator with a copy of the will attached. But creditors don't do that. They're not really that interested in that, unless it's like a landlord or something like that. Like MasterCard's not going to come forward. They don't want to be the administrator. They just want to get paid. And but they can force the issues so that I'm obligated to appoint somebody to manage the estate if the family doesn't come forward to act.
And Councilwoman, that was an excellent question in terms of if somebody didn't want to, because this is part of communicating with your family members, whether it's the durable power healthcare
That should have been, you're right, Devero. That should have been avoided right from the start.
You should communicate, right? You should communicate with them to let them know, I want to appoint you, because they may not want to. They don't legally have to do it. Many times we have people come in and do what's called renunciations, which simply means they renounce their rights to be the executor of the estate. Or if it's administration, they don't want to be the administrator of the estate. So although you are naming individuals in these documents, they technically don't have to do it. Like I was saying earlier, you know your family, and you should appoint the people that will handle your business as you want them to handle it. But you should have this conversation, just as you will have an open and honest conversation with your lawyer. You need to have one with them. Just like as the surrogate talked about, you had a niece that took care of you, but a son that didn't. You didn't do a will. Well, if you did a will, you can be honest with that son and say, listen, this is why I'm giving it to my niece, because she did X, Y, and Z. Or you had 3 kids, you're not doing it a third, because you feel as though one has done well, and so I want to help them out a little bit more. That's part of the open dialogue that you should have also with your family members as well. And one last thing I'm going to say about this: the individuals that you appoint, whether it be attorney in fact and your power of attorney, your healthcare proxy, your administrator, your guardian for the kids, does not have to be the same person. It can be different people, like I indicated before, and I can't emphasize more, based on your family. You understand your family, you know who can do those. So it doesn't have to be the same person. You can mix it up depending on who you think is more suited to handle it. And when you talked about bonds, so if somebody's having credit problems, well, first of all, you don't want to have, like I said earlier, don't handle your finances. But if you don't put a bond provision in your will, they may have to get a bond. If they have credit issues, they might not be able to get bonded. So be mindful, and an attorney will help you with all of these things as well.
That's what I was going to ask about the bond too. The question about the bond, if there's no will, is somebody still needs to be bonded to be the administrator? Is what you're saying?
So it depends on the value of the estate. So there are small estates in New Jersey. So a next of kin estate is for any assets that the decedent had that are 20,000 or less is considered a small estate. If it's a spouse, 50,000 or less is a small estate where a bond is not required. If it exceeds those limits, a bond is required unless a superior court judge decides to waive it. But fiduciary, I'll make a general statement. In New Jersey, anybody with a fiduciary role, in all likelihood, will probably get bonded because you are put in charge of somebody else's assets, estate, and you know, the wisdom of our lawmakers over the years said we want to protect it and make sure that if anybody runs away with that money, well, the beneficiaries of it, they can put a claim against the bond, and instead of chasing after the individuals that stole the money or didn't distribute it correctly, they could put a claim against the bond. You'll get paid out based on that claim that you put against the bond, and the bond company will go after that individual. So in that regards, it's a wonderful thing for the beneficiaries, the creditors, that they don't have to chase down somebody because the insurance company will pay it out, and then they're ultimately responsible for tracking down the person who would have stole the money or you know, basically stole the money.
Essentially, yeah. So there was a question too about, you know, inheriting a property that's in the foreclosure process. Is that a legal question, or who wants to take that one?
I think Michelle probably more suited for that. Michelle,
right?
What was the question?
So I'm inheriting a property during the pandemic, but it's in foreclosure. What happens?
Well, I mean, if there's you know, if it's being foreclosed, I guess there's no value there, right? I mean, there could be some equity. If there's equity after it's foreclosed, unless they, you know, maybe they want to pay it off. You know, they have to see where in the I don't handle foreclosure, so I'm not sure how they go down. But at the end of the day, if there's anything left over in the estate, then the person takes. But if not, you know, if you are the executor, for example, you're not personally responsible for the debts of the estate. So there shouldn't be a fear to go and, you know, be the executor and qualify for the executor. You wouldn't personally be responsible for the debts of the estate, but you should, you know, if there is if in this case, if that's the concern, that the property's in foreclosure and there may not be sufficient assets and all this, they should still, if they think that potentially they would get some assets, they should still qualify as executor and go through the process, because they wouldn't personally be responsible for any shortfall.
And if I can add to that, and if you become appointed the executor or the administrator, depending on the situation, you may be able to negotiate with the lender to avoid the foreclosure. So it depends on the situation. And part of what Michelle is saying as well is, you know, it may be worth allowing them to take it, and if there is equity in it, then whatever the difference is, you go ahead and distribute it. And I will add this: if there is a federal law, and I apologize for not remembering the exact name of it, but if you inherit property, that the lender cannot kick you out the house right away. They have to give you, and if you're a son or whatever, and you were living in that house and you inherited the house, they have to give you an opportunity first to go ahead and get a loan, and before they can just foreclose on the property. So don't be afraid if the lender knocks on the door and you think that they're going to go ahead and foreclose and kick you out, because there is a federal law that protects you to allow you the opportunity first to see if you can go ahead and transfer the property over, if it's a will according to what the will says, or if administrated according to what the statute says, and go ahead and finance the house before you just simply get foreclosed on and kicked out.
Let me ask this question: what, if any, is there an inheritance tax if there's no property? If there is property, let's talk about that a little bit.
Sure. So
we're in New Jersey with all the taxes, by the way, people. So whoever might see this someplace else.
Yeah. So in New Jersey, luckily, we don't have an estate tax at the moment. There used to be. Now there isn't an estate tax. Federally, we're talking about roughly 11.7 million that each person can transfer without incurring a federal estate tax. Now, in New Jersey, there is something called an inheritance tax, and that has less to do with the amounts that are being transferred, like the other two just like the estate tax. It's more to do with who is receiving the property. So Class A beneficiaries, which are you know, your children, grandkids, they are not, there's no tax there there's no inheritance tax on what is inherited. But if you're going to leave to almost anyone else, I mean, aside from spouse, obviously, there will be. So like if you're going to leave something to a niece or nephew, there will be likely an inheritance tax. anything in excess of $15,000, right? 15?
Okay.
Right, and no inheritance tax for if you give it to a charity.
Right. No.
A church, a synagogue.
Very true.
I'm sorry, but we've done a lot of these with churches, so I always got to throw in the church.
I forgot about the charities. I should have said that. Yes.
Okay. That's awesome. Wait, let me just unmute Jim.
Yeah.
Do you have anything to add to that?
Yeah, there's no inheritance tax on spouse.
Yeah.
Michelle didn't mention.
But let me ask this question though. So I know New Jersey is not a common law state, right? So I've been his boo forever and ever, and he called me his wife in public. We've been together more than 7 years. That's not a thing in New Jersey. However, I live with you for 20 some odd years. We have no kids, unfortunately, or maybe fortunately. And then, the untimely passing comes, and, I have nothing. Like, there's no will, there's nothing. So you go to the workplace and say, did Johnny have insurance? And they go, yeah, but his kids that he had with his other girlfriend are what is that? How do you manage that? So who's responsible then? Am I gonna owe his bills or who? Not me, but I'm just saying.
Well, you wouldn't owe the bills, right? You wouldn't be legally responsible for the debts of the estate. You wouldn't inherit you wouldn't take from the life insurance, because the life insurance goes by that beneficiary designation.
Mm-hmm.
And if you name the kids are getting it. And if you died without a will, the kids are getting everything else too, after the debt is paid off. So
and that's unfortunate. There actually, a few years back, I recall a story in New Jersey where just that same scenario, where a gentleman was with a woman for multiple years and probably 20 some odd years, and they bought a nice house down at the shore somewhere. He died, and he died. His daughter from another relationship decided that the woman that he's been with for years, she didn't want her living there. She kicked her out the house, because ultimately she had no say. So those situations happen, and I know surrogate law court can attest to this. Many people have come to the court, and we have to unfortunately tell them they are not entitled to be the administrator, nor entitled to inherit, unfortunately. And there's nothing we really can do, because in the eyes of the law, under the intestate statute, they're a stranger.
Well, at the risk of offending somebody, okay, and I don't know who's listening or watching this presentation, but at the risk of offending somebody, we have new arrivals to the American shores. And whatever past country they may have lived in, if they've lived together for a certain number of years, it's common to refer to the person as their husband or as their wife, even though they never went through the formal ceremony. And I see that constantly, where somebody will come in, they're newly arrived in the United States, or maybe they've been here for a while, but they're going by the traditions of a country that they're coming from. And as a result, they may call her the wife, they may call him the husband as much as they want. They're neither. They're considered to be a private citizen, and they're not your husband, and they're not your wife. So without the formal ceremony, then it's just as if they never lived together. That's
surrogate court. Here we say
I can't make it any plainer than that.
Surrogate court. Here, it's not. They don't have to be overseas. Here, they call them their wifey. So it's not necessarily overseas. So they think the same thing.
And just to add to that, on the flip side of it, I mean, I deal with a lot of Spanish-speaking. I'm of Hispanic descent, and so I have a lot of Spanish-speaking clients, because I speak Spanish, and a lot of them think, because from their country of origin, their laws are different, and so a lot of times the kids inherit, not the spouse. So they're actually expecting that their kids are going to get this. Well, my kids get it when I die, and or at least a portion of them. Like, that's not the way it works here. You have a spouse, and all the kids are from the same marriage. Your spouse is going to take. Your kids aren't getting anything. So
where that happened? You're too young to remember this. I'll tell you exactly what happened. The law changed in 2005 after September 11th, because people found out that under the old law of intestacy, the wife was entitled to the first $50,000, and then the husband and wife would, the surviving spouse and the children split the funds. So then after September 11th, what happened was the
Jim, you got low. Pick your phone up.
Realized that the spouse wouldn't get everything, and all of these nice homogeneous families in other places, and were going to not, the spouse was not going to inherit the funds, and she had to share it with the children. And the legislators didn't think that was a very good idea, and that the spouse should have all the funds, because they were considering a family with a lot of young people. Because if you look at the results of September 11th, what happened was a lot of young married individuals died, and as a result, the spouses were forced to share the intestate estate with minors, and they didn't think that was a good idea, so they changed it. Well, what I've seen far more since then is the scenario that I described earlier, wherein you have long separated spouses, they never bothered to get a divorce, and as a result, the long separated spouse winds up with the estate, and the children get nothing. Okay, the legislature, in their wisdom, overlooked that more common scenario, and went with the one that would take care of the spouse individually, to the exclusion of the children. But that all came about as a result of September 11th. Now, as an example, on September 11th, 60 people died in were residents of Union County. Okay, and I've seen far more long separated spouses since then inherit a complete estate, rather than the number of people that died on September 11th whose families had to share it with minor children. So that's just an aside. That's why that came about.
Okay. So I have two short questions.
Historically interesting.
I have two short questions before I let you guys go, and I have to give my updates from the Fifth Ward. So what about same-sex couples, right? Let me just look at my question again. Hold on. Same-sex couples, do they have any rights in will handling affairs? So the will names, you know what I'm saying, like the same sex, even though some states don't recognize.
No. Will trumps everything. The
will trumps.
Will trumps everything. So prior, let's say there was no will, then before there was same-sex marriage, then that was a problem. Okay. But now that there's same-sex marriage, the same rules that apply in intestate statute apply. So the first person to inherit under the intestate statute is the spouse, domestic partner, civil union. Did I say that right? Yeah. So civil union. Right. So those people, those individuals are on the same line. But in terms of a will, the will trumps everything. So and this, like I said, it doesn't really matter. You can, now I will say this though, and I don't know if this, I'll just add this. Technically, you can disinherit a spouse, but the reality way our state statute works, that person has what's called elective share, and then they can file a suit and say, but the law says I'm entitled to approximately 1/3 of the estate. I want that, but they have to affirmatively do something about it. So although you can technically disinherit it, there is a way they can still get their money. So just similar to what Surrogate Court is talking about, when somebody's been separated for 20 years, and you try not, you want to disinherit them, but you didn't divorce, they still technically can get some of their money. So if you didn't want to get it, you should have divorced them. So I just wanted to add that piece to it.
I'm gonna leave that alone. I was gonna say something. So here we go. Last question. What documents are needed in your court to probate a will, and be an administrator and so on? What does one need to bring with them to get this process started? And wait, is there a cost up front?
So let me answer that with a general statement. Everything has a cost to it. Okay. And we all know this in life. So unfortunately, there are filing fees in the surrogates court, but they're reasonable. Okay. New Jersey is not like New York, and Florida and some states like that, where there's automatically a court case where that you have to go before the judge and have like a formal proceeding. We have an informal procedure, so you're not necessarily going to need an attorney. If the situation is clear cut, So approximately on average, the fees are somewhere between, and depends on what the situation, somewhere between 100 to 175 on average. So it's not a big fee to do the processing of it. And in terms of a will, if you want to probate a will, you need to bring the original will, an original death certificate with the raised seal. You need the executor should bring their ID to prove who they are, and of course, be prepared to pay a fee. So you need funds with you. That's for a will. For administration, what you need is one to prove that you are who you say you are in the line of the inheritance. And so, some circuit courts may do it a little bit differently. I mean, I will speak for Essex County. One of the things we always want to see is a marriage license or, a certificate for domestic partnership, because as surrogate court says, many people have come and said they were husband and wife, and we realize that happens far too often. So we need proof of that. You need the list of assets of the individual that passed away and the value of those assets. And the reason why we need the value is to determine whether or not a bond is required. As I indicated, the threshold before, that would dictate that. And that's the basic requirements of to come to the surrogate court to do administration. And the fee, of course, and the fee as well. I don't want to forget that.
Well, no, you got to bring the fee. So is there a deadline? So my cousin dropped dead, today of, a heart attack, and 3 months later, then the daughter's coming to try and do the will. Is there like a deadline? Should they,
So there is a deadline for the minimum time you can come forth to either be the administrator or the executor, but there is not a deadline in terms of when you can come into the court to probate a will or do administration, because I've seen wills not get probated for 10 years or stuff like that. So, but the deadline is, in order to probate a will, 10 days has to have passed after you passed away. So basically, the 11th day after death, you can probate the will. If there is no will, 5 days have to pass. The reason behind that is really to give, if anybody wants to object to the will, they have time to object to the will. And it's similar to the administration, but the thought process kind of sort of is, it's going to be given to the nearest and dearest, so most people aren't going to contest anyway. It's the thought process behind that. So I get, because the statute is set up that wife, children, parents, siblings, and inherit. Therefore, most people aren't going to contest. That's the theory behind it. But minimum days to probate and do administration, but there's no maximum date set.
Okay. Well, I appreciate you all very much. Very, very much. Michelle is going to share with me the legal presentation that we can offer. If you would like that, just send me an email. And Mr. LaCourt, I think we're still looking at your ear. We want to thank you for joining us tonight. Wait, hold on. Let me unmute you because you be having background noise.
Okay.
There you go.
Thank you for having me.
My pleasure. And again, thank you guys so much. Essex County is out here and they're helping out the community. I appreciate that. I still have family in Essex County. I'm actually, I don't know if I should say this, considering going back to Essex County, but so thank you so much. It was great to be with you guys. I'm going to continue on and do my updates, and I will see you all soon. All right, take care. Thank you.
Thank you. Bye.
Take care. My pleasure. Thank you. All right, folks, that was awesome. Some of the questions, like, did you understand that? Did you know that? Like, are you kidding me? Some of the stuff is like, I didn't know, like, wow. But listen, don't pretend like I have nothing. Don't say you have nothing. You have things of value. And for example, you have a photo album. Who has photo albums? Antiques and things like that. Those things are valuable, and you'll be surprised who in your family might want to get their grubby little mitts on it. So you need to get a will. Michelle's information is here, and she does speak Spanish, right? If you need her to help you get a will, come in with a rough draft, basically, and then let the attorney go ahead and do what they do and make sure that it's solid and nobody can go and contest that will. So that was awesome. It took, took a year to get Mr. LaCourt, so I'm glad he was able to join us tonight. Anyway, so in the 5th Ward, If you did not see the council meeting, I'm going to give you a brief of my report. We are looking for the light at 1600 East St. George's Avenue to be illuminated. We're waiting for the state to come up with the parts. I did see them working as I was driving around the neighborhood, so I'm excited that the light's going to be a push to stop. It's right at the bus stop. We have folks going across the street back and forth to the stores, to the laundromat, and it's for safety. It's a shame that it's been so many years, but I am proud to have been the champion making sure that we are saving lives here in the 5th Ward, and we're going to have that push to stop light, and it's about time. So look for that. I'm actually driving around the ward and looking at the condition of some of the streets. As I said, we get to put in our wish list, and by the week's end, which is tomorrow, even though it's a city holiday, I'll still be, gathering my list so I can submit that to the engineering department and see which ones we can get. Just be reminded, Fay Avenue has already been approved, and there will be rumble strips there too. So as soon as the pre-con meeting goes on, we get the information, I'll share the date that the resurfacing on Fay Avenue is going to take place. Surprisingly and gratefully, I was pleased to learn on Tuesday, we just found out on Tuesday, that there are going to be summer jobs. And as soon as I found out, I sent an email to the 200 some odd folks on my list, and I immediately got responses, which means the 2 10-week positions that I have to recommend children for have already been assigned. There are 3 positions, however, for a once-a-week Clean Communities program for anyone who's 15 years of age and older. So if you wanted to get that information, please contact me, send me an email. If you want to get on my email distribution list and get city updates, please do that as well. I'm pleased to announce also that the senior bus, at the Tuesday meeting, there was a driver hired, Ron. Hey, Ron, congratulations. Ron is going to be the new bus driver. The bus will resume the scheduled routes on Monday, the 21st of June. Mask will be required. And the annual fee-free yard sale for our ward is going to be the 3rd Saturday, like it was in 2019 of August. So save the date for August 21st and August 22nd, Sunday, as the rain date. This way, you don't have to worry about when is it. We know when it's going to be. We're going to be consistent, and we're going to always have it on the 3rd Saturday of the month of August. So it's in between everything, and folks are usually, preparing to get rid of everything and get ready for fall. The summer concert series is back, and this is exciting. Thankfully, you don't have to register anymore, so that's not a thing. I'm going to, the schedule is here if you want to take a look at the schedule and see, who you want to go and see. And if not, you can always contact the recreation department. So you have the comedy nights on Thursdays, you have the concerts on Tuesdays, and I'm excited to be outdoors at the promenade and just enjoying that. Okay, again, tomorrow is a city holiday. It's impromptu, however, it is a celebration of Juneteenth, and I don't know if you all may remember or not, because I know that the city wouldn't promote the event, and it was funny to me, but it was okay at the end. I did a Juneteenth 2019. We tried to, do a little program where we had music and we had guest speakers. We had the spoken word. It was really awesome. It was been recorded and it was playing for quite some time. I wanted to just, say thank you again to Beatmaster Productions and Asad for that, because it was an awesome program. Poorly attended, I will not lie, but the program itself, when you look at it, it was awesome. And I know this year it's a big thing because now people actually know what Juneteenth is, and it's just hilarious. But anyway, the last thing I wanted to, I don't know how to finish sharing my screen, but let me just tell you that the city council is looking at finally the zoning of the cannabis, retail, recreational, whatever, all of the 6 licenses. We, at the workshop on Monday, had a conversation, and to my chagrin, I will say, nobody really understood what was happening, what they were about to vote on. They were getting ready to deny the delivery business license for the city of Linden, and they also planned to deny any retail establishments. And so it's bigger than that. I feel in my belief, I should say, the recreational marijuana can live if we limit how many. I mean, it's a whole conversation that we need to have. And so there's a liquor store within, let's say there's like 8 liquor stores within a mile here in the city of Linden. So then you might as well go ahead and license and allow a certain number in a certain area of recreational or retail. So that's my only argument. And also there's a slight benefit. I mean, nobody's going to get rich off the 2% tax or whatever. But again, it's here. The marijuana is here. It's not going anywhere. So the council president has announced that she's going to plan a special meeting. And I hope that whoever has an interest in understanding it or getting involved in the business, you all will attend. More importantly, the Cannabis Regulatory Commission has a scheduled meeting on July the 13th at 6 o'clock. Get the information, get the link at the New Jersey website, okay? You need to get the information for yourself. Don't let somebody shove information down your throat. Get it, understand it, digest it, ask your questions, and then, reach out to your council person and ask them to support whatever your, intentions are for this. Because at the end of the day, I get so tired of hearing at every council meeting, residents being chastised about their behavior. Listen, we work for the residents, okay? And if there's a certain thing that needs to be done, or if there's a matter coming about, give them the honest facts and the truth. Let them, guide us, right? Now, we may not agree with everything. And then if we don't agree with certain things, then just vote your conscience at the end of the day. But at least let people express themselves and share, their thoughts. And lastly, there is a bill that's going on Monday at the Senate. The bill is A4656. And I have talked about this before. Again, clap for the city of Newark for wanting, they actually got the ball rolling on this. This is for the Civilian Review Board at the local municipalities. And this is going to be very important. I don't care if you don't feel like there's a problem. There's always room for oversight. Everyone has a boss, right? And then that boss has to follow certain procedures. And that's why we have, the whole attorney generals and the police, everything. Everybody has to be accountable at the end of the day to the members of the public. And that's why I wholeheartedly support A4656. I'm going to tell you, you need to check it out for yourself, see who's voting for this or against it, whether you agree or disagree, whatever your interests are, so you know how to vote in November. Because just because somebody won a primary for whatever their party is doesn't mean they are guaranteed a seat. I'm going to say it again. Just because you have a recognized name or somebody who won in their party's primary does not guarantee them a seat, especially if there's a challenge. All right? So I just wanted to put that out there. Again, my technician is not here, so I don't know how to get rid of my screen right now. So give me a second. It's all good. Let me see if I'm going to remove this. Might remove myself, but I did it. Yay. I miss Cece. She's supposed to be here doing this for me. All right, so just as a recap from the surrogate's office, this is the Essex County information in their brand new building. They have a phone number that you can contact them. They have an email also, right? Shout out to Nikki making this happen. Appreciate you. This is the Union County Surrogate's office. Just so you understand, the Union County Surrogate's office is located in the courthouse. However, you need to enter through the back. It's not open right now. The building's still not open. You will enter through the rear of the building in the handicap entrance because the front steps, they're still doing construction over there. So when the building does open back up, you go in and they're upstairs. All right, just ask the sheriff officer and they will direct you and guide you to the right location. And it's a necessity at the end of the day. So I remember seeing a woman and, the husband passes away and she's coming and I was actually walking, I was going in the building myself. And she asked where the surrogate's office was. And, I directed her to the place and everything. And she just looked so somber and so, so sad. Of course, you lost your loved one, but you still have to take care of that business. Okay? You got to take care of that business. Let me just find this right here for you. All right. I'm sorry. I'm moving slow. So just bear with me. The recreation contact phone number is 908-477. No, It's my phone number. It's 908-474-8600. I'm being told, we were told that they're still hiring. And it's funny because we know several months ago that City Council had changed the rules for education. They are not requiring high school diplomas anymore, right? Unless the civil service says so. So my question to them, and I still have not received an answer since Tuesday, actually since Monday from personnel. So then that means that that weird 1 year requirement for someone to work in playgrounds with children should also be removed because it's not required by civil service. And I remember clearly having adult women who had teenage children get denied an opportunity to work in the playgrounds program because they didn't have a year of college. You gotta be kidding me. So anyway, there's still jobs available in recreation. Call Mr. Dunham, find out what they are and see what the process is. And if I get an update, then I will let you know as far as what the education is. Now, next week, I have a guest, and it's been scrolling the entire time. We have attorney Hassan Abdallah. He's right here from Linden. He's been here working hard. He specializes in criminal and family, right? And he's going to talk to us specifically about the 2017 New Jersey criminal justice bail reform. Who is it helping and who is it hurting and how, right? If you've had an experience, like, so the judge is going to say, you know, you're going to be able to leave the court on ROR if you were arrested. Okay, great. But then that judge also has the power to retain you and not allow you to make any bail whatsoever if you're deemed to be in a danger to yourself or someone else. I don't know. To me, I feel like that's a little quirky, a little subjective. You got to see, where that judge is coming from, what their biases may be. And Hassan is going to speak to that directly as a criminal defense attorney. Thank you for watching, and I will see you next Thursday at 7 o'clock. Stay tuned.